Okay, folks, let's get started. In this video topic, I'll hit the high points of something called the impossibility doctrine in criminal law. And here's the short version of the story. It's a really complicated and frustrating doctrine. Frustrating because it's applied so unevenly, it's so unpredictable. But ultimately, this unstable, shifting doctrine really doesn't matter so much because most jurisdictions have moved past the common law version of the defense to create a much more limited version that tracks something like what we see in the model penal code. This is a defense that applies when a defendant is charged with attempt. And the defendant says, okay, maybe I attempted to commit the crime, but it turned out it was impossible from the beginning for me to have succeeded. Consider this as a classic opening example of the doctrine at work. We've got an assassin sneaking into the target's bedroom. She sees the target, she thinks, sleeping under the blankets, empties the handgun into the body, but it turns out there's no body there. It's just a pile of pillows under blankets. It was impossible from the very beginning that a murder would have happened there because there was never any body, there was never any human being to cause the death of there. It was impossible. Scenario brings to mind a famous scene from American cinema. Let's remind ourselves of the example. With that edifying example in mind, here's the common law rule that we're working with. Doesn't help much, but it's a rule. Sometimes we allow the defense, sometimes we don't, depending on the reason for the failure of the crime. What the common law says is that legal impossibility is a defense, while factual impossibility is not a defense. The trouble is that it turns out that lots of things that seem like facts turn out to be legal impossibilities. Lots of things that seem like legal consequences turn out to be factual impossibility. It's been quite a slippery concept. Happily, as I mentioned, the great majority of jurisdictions have abolished this particular way of dividing up the world. But let's walk through it as a matter of common law. So first of all, for legal impossibility. As I said, at common law, legal impossibility is a valid defense. So a few classic examples would be taking a lawful tax deduction, even though you believe it to be unlawful. Or if I'm smoking marijuana and I think it's illegal to smoke marijuana, but it turns out that I'm in Colorado, and this is not a violation of the state criminal code. So I haven't actually violated the law in the state. Sometimes this particular version of the defense is called pure legal impossibility. In contrast to this situation where the defendant has some mistaken belief about the legal status of some action, there's a different form of legal impossibility that is a defendant who is mistaken about some combination of fact and law, mistaken about some kind of fact that has legal significance. This is sometimes called hybrid legal impossibility. An example would be, I am suborning perjury. I'm trying to convince somebody to commit perjury, but it turns out that the testimony I want them to lie about is immaterial. Or I'm bribing a person who I believe to be a juror, but it turns out this is not a juror. Or in some cases, in some jurisdictions, we have cases where a hunter shoots a stuffed deer out of season, believing it to be alive, but it turns out it's not a live deer, it's stuffed. And so, mistaken about the legal status of the thing that I'm shooting at. Another classic example would be a defendant who accepts goods that are thought to be stolen, but the goods are not in fact stolen. All of these are, at least in some jurisdictions, sometimes ruled to be a form of legal impossibility, and therefore it's a defense. The trouble is that you can find holdings on the other side of this, where the court says, no, this is not really a mistake about legal status. This is a mistake about the actual factual nature of the thing. You thought this was a live deer, but factually it was not. It was a stuffed deer. You thought this was a juror, but factually it was not. It was somebody who was not a juror. So you could characterize it as a mistake about the legal category that this thing belongs in, or you could characterize it as a mistake about the actual nature of the factual thing dealt with. What it comes down to is some kind of mistake about an attendant circumstance. So these are the hard categories. Some places will hold that it is a defense because it's legal. Some places will hold that it is not a defense because they push it over on the fact side of the line for factual impossibility. That brings us to the factual impossibility category, where the common law courts say, no, if it's factual impossibility, this is not a defense. So we typically say that factual impossibility is not a defense when a crime is impossible because the completion is simply missing some kind of physical or factual condition unknown to the defendant. Classic case here, very common, a frequent situation here would be a child sex abuse case on the internet in an internet chat room where the defendant thinks that he's arranging some kind of clandestine meeting with a underage girl, but he's actually dealing with an undercover police officer who's posing on the internet as an underage, a child. In those situations, quite typically the courts say that's factual impossibility, even though it was in a sense impossible to commit the crime of child abuse and therefore maybe attempted child abuse. They say, no, doesn't work. That was a factual impossibility and not the kind of thing that we will treat as a defense. Similarly, pickpocket tries to pick an empty pocket, nothing in there. Could say, hey, it was impossible from the start for me to steal anything from that pocket. But the courts say, no, that was a factual impossibility, not a defense. Again, this is where the Nazgul and Bree come in, where the assassin who's trying to kill somebody in bed, who's under a pile of blankets, and they believe the body's there, but it's actually just pillows. This would be a classic case of factual impossibility. Other situations might involve pulling the trigger on your gun when it turns out that it doesn't have any rounds in the chamber. You thought you were going to shoot, but you failed because there was no ammunition in the weapon. So some scholars put the distinction this way. They say that factual impossibility in the common law terms is really about a defendant's error about some conduct or result element, and legal impossibility, where the defense is available, is some kind of error about a circumstance element. Let's talk about an example case to apply this doctrine. Let's imagine that we've got a defendant who is convicted of a crime and is really ticked off with the judge and wants to get his revenge on the judge by killing the judge through voodoo. And so the defendant arranges with somebody who cleans the judge's house to obtain hair from the judge's hairbrush and to use that hair as part of the voodoo curse on the judge, fully expecting that this curse will kill the judge. Can you charge this defendant with attempted murder? Is there an impossibility defense here? Well, if you use the common law category, this is probably a factual impossibility. That is, the defendant is only mistaken about the deadliness of using voodoo as the method of killing the judge, and is not mistaken about the legal status of the action that the defendant is proposing to pursue. Or if you use the more modern characterization, you might say that this is some kind of confusion about a result element causing the death of another human being, rather than some attendant circumstance element. And so again, you might say no defense. How might you analyze this under the model penal code and under the law of many states that have now adopted something like the model penal code approach? Well, under section 5.05 of the model penal code, you just ask, did this defendant engage in some kind of conduct that would amount to murder if the attendant circumstances or the actions were as he believed them to be? There's an exception under 5.05 that says if the conduct that constitutes the attempt, conspiracy, or solicitation is, quote, so inherently unlikely to result in the successful commission of the crime that this conduct or this actor just don't present any public danger, then in that setting the court can impose some kind of conviction for a lesser offense, some lesser grade of the offense. So this exception offers some kind of mitigating offense, a partial defense, but not a complete defense. Notice, though, that under the model penal code, as always, we're interested in mental states. Did the defendant plan to do something that at least he thought was dangerous? And if so, then some kind of punishment is appropriate, because the model penal code is more subjectivist than objectivist. It's more interested in dangerous states of mind than it is in the actual harm that flows from those wicked or dangerous plans. So anyway, that covers the ground for impossibility. But remember, even though the legal impossibility versus factual impossibility distinction of the common law is hard to apply, you end up with very confusing results. You could probably argue very persuasively that any given case belongs on one side rather than the other. Even though there is that instability, most states have moved beyond that now, so that they say normally impossibility is just not a defense. We're just going to ask the normal attempt questions. Did you do some kind of substantial act that was, or some other act that's sufficient under state law to qualify as the attempt in a way that indicates that you had the intent to carry out the offense. So that's the impossibility defense. We'll talk next time.